Uh, Thank you, Anthony, for inviting me to contributing to this wonderful network, and thank you for this generous introduction, and thank you all uh, for taking the time to engage with my work. I'm really glad to be here. So I would like to begin by giving you an overview of the project, which is, as Anthony mentioned, my third monograph published last year, by summarizing what I see as the main 7 contributions of the book. Then I would like to zoom in on the main moves that I make in the book in terms of both intermediaries and viewers. And then I would like to delve into 2 or time permitting 3 points. The usefulness of thinking of hosting and viewing non-consensual intimate images, I would usually refer to it as NCII, is selling and buying of stolen property, what I call in the blurb conflict over titles and the inalienability paradox. The contribution of tort law, tort theory, and in particular egalitarian tort theory to the way in which platforms should be regulated, what I call NCII exceptionalism and the critique of the inverted hierarchy of rights. And finally, time permitting, criticizing, so I'm just trying to, yeah, criticizing the regulatory gap in how we regulate child pornography and how we regulate adult image sexual abuse. So the book is a culmination of research supported by a Liverpool Fellowship, and it attempts to answer the question whether internet intermediaries, mainly hosts, should be civilly liable for hosting non-consensual intimate images, and whether viewers should be liable for merely viewing these images without doing anything more. And my answers are that both hosts and viewers should be liable and that the liability should be strict. The methodology I use is both relying on first principles, analogies, and private law theory to defend the claim that hosting and viewing non-consensual intimate images should and could lead to liability for breach of privacy, and engaging in policy analysis in order to justify this liability and curb it so it would not necessarily be applicable to other rights violations. And I think I cover in the book quite a lot of ground, but here I would like to introduce 7 main points. First, functionally, hosting non-consensual intimate images is equivalent to selling stolen property and viewing them to buying stolen property. It does not make sense that the legal system would afford me better rights against those who sell and buy my stolen car compared to those who sell and buy my intimate images. This conclusion should be held whether or not one views private information as alienable or not. According to the inalienability paradox, it does not make sense to protect inalienable rights from unauthorized intervention by third parties to a lesser extent compared to how property is protected. So at least as long as liability under conversion is strict, so should be liability for hosting and viewing unauthorized intimate images. But in fact, we have stronger reasons to protect the claimant from undermining the control over intimate images than the control over personal property. So even if strict liability for conversion is too harsh, this is not the case for strict liability for hosting and viewing NCIIs. Definitely, there are strong policy reasons to hold hosts strictly liable for NCII, like all other merchants. Second, doctrinally, there is recent support for classifying misuse of private information as intentional tort for which liability is strict. In England, the Supreme Court decision of Lloyd and Google, and in the US, Powerline and the US. And for treating each viewing as a separate intrusion for which there should be liability. In England, Douglas and Hello number 3, and Gulati and MGN. And in the US, the tort of intrusion upon seclusion, and Powerline. Third, Similarly to the way child pornography is regulated, there should be a distinction between active and passive viewers. So a viewer who receives an unsolicited intimate image and promptly deletes it would not be liable even if the image was non-consensual. More generally, at the level of policy, there is an unjustifiable gap between the way child pornography and other cases of non-consensual intimate images are regulated. Once child pornography is understood as to be subcategory of NCII, albeit an extreme one, the regulatory gap becomes untenable. Both phenomena are instances of not only breach of privacy, but also of sexual abuse. Fourth, due to the overdetermined nature of causation to the harm from viewing NCIIs, the liability of each viewer should be to a significant amount, but not to the entire damage from breach of privacy. This too helps keeping liability for viewing in check. Liability of host should be to the entire damage. There's good argument for the proposition that even if host liability remains limited to failing to remove expeditiously the image post-notice, the notice and takedown approach, in cases of such failure, liability should be for the entire damage, including the pre-breach period, as the damage is indivisible. Fifth, from a regulatory perspective, platforms should be subject to an upload filtering obligation backed by strict liability for damage from any NCII appearing on the platform. The ECD horizontal approach in Europe should be rejected, and at the same time, the stronger protection that owners of copyright have against hosts in comparison to the rights of victims of breach of privacy, both in the US and in Europe, should be reversed. I call this the inverted hierarchy problem and call for NCII exceptionalism. The harm from NCII is irreparable, all-encompassing, lasting, systemic, gendered, and on the spectrum of sexual abuse. And monitoring is feasible and has low cost in terms of chilling effects and economically. The reverse is true with respect to copyright and to a lesser extent with respect to defamation. In this regard, the availability of interim injunctions for breach of privacy as opposed to their unavailability in defamation should be translated to the way intermediaries are regulated. Intermediaries should filter content threatening sexual privacy, i.e. intimate images not verified as authorized, but should be under no equivalent obligation to filter potentially defamatory material. To the same extent that my access to my bank or to my employer services online depend on verification of identity, so should the posting of intimate images depend on identified proof of consent of those depicted in the intimate image. 6, contrary to policy, the policy direction of travel in both the EU and the UK, platforms' obligations should not be based on the size or means. In terms of principle, since they actively contribute to the undermining of the right and to the ensuing harm and do so for profit, the logic behind taking into account financial means in terms of delineating the scope of affirmative duties is inapplicable. Moreover, unlike in cases of breach of copyright, the damage to the claimant is not likely to be linear with the number of viewers. As long as those who are likely to recognize the claimant are also the likely users of the platform, the harm is significant, so smaller platforms should be subject to the same obligations as bigger ones. Any anti-competitive effect is far outweighed by the injustice to the claimant if strict liability be denied. More generally, the research highlights the need to take into account the fact that the harm from breach of privacy is disproportionately caused by those who are likely to know the victim. Finally, misuse of private information should compensate for the direct consequences of the breach of privacy, even if unforeseeable, at least if there is intention to harm. So if you know that the intimate images are non-consensual. It should also compensate for the reputational losses ensuing from the breach of privacy. And while less relevant to NCIIs, liability could be both for the mere undermining of control over the private information and for the consequences of the breach of privacy, similar to what was decided in Gulati in the UK, and similar to the possibility in libel law to award special damages in addition to liability at large. So this is the summary of, as I said, of the main points. And now I would like to zoom in a bit because the book has two main parts, one about liability of intermediaries, mainly platforms, and one about viewers. So to say few more points about the moves that I make in respect to each. So starting with the intermediaries, I begin by criticizing the American approach in Section 230 of the CDA of complete immunity by challenging the view that intermediaries are merely conduit based on first principles of control, a profit motive, and users' right for effective remedy. I also showed that analogy with occupiers' liability. If you think of the platforms as merely giving, space, for people, to post. So analogy with occupiers' liability, nuisance, and the offline defamation cannot justify immunity beyond notice. The third point, as I mentioned earlier, I criticize the relevance of means given the active contribution. Once you understand the platforms to actively contribute to the violation of the right, so the means limitation is not justified. The fourth point is to criticize the notice and takedown model, which is the European approach in the ECD, given the analogy to conflict over titles, that justifies strict liability. So I mentioned it earlier, and I will talk about it a bit more soon. And then I tend to justify strict liability based also on policy considerations, mainly on how exceptional the harm is. The harm is irreparable, and the priority of preventing a breach of a right over compensating it. So again, I will talk about it more later. So I call for NCII exceptionalism. So this special duty to monitor backed up by strict liability. And I criticize both the starting point in the EU framework of horizontal model, that it doesn't matter what the breach of the right, the liability or the immunity of the host is the same. And the inverted hierarchy according to which copyright holders enjoy stronger rights against intermediaries compared with NCII victims, despite the fact that normatively the opposite should be the case. And then the last point I already mentioned briefly earlier, that even under the existing notice and takedown European model, the fact that the damage is indivisible should lead to liability if there's a failure to remove it expeditiously, given the fact that the damage is indivisible. Turning to the book main moves in terms of viewers. So I argue that viewing in itself is intrusion, is intrusive, and that this is compatible in the US, with the restatement's view of the tort of intrusion upon seclusion, and with the US Supreme Court decision of Powerline, which dealt with the apportionment of damages of a massive viewing of child pornography. And it's also compatible with the way that the misuse of private information was developed, both the cases of Douglas and Hello and Gulati. So I have a chapter that starts from the easy case, of child pornography as a case of NCII, and then saying, there's no reason to distinguish, if what you do is looking for intimate images because they are non-consensual. Then I move to objective fault, which is in the context of Pornhub and others, porn platforms. Uh, so I'm saying that even if liability for breach of privacy requires show of fault, which I dispute, so at least in the context of porn platforms, the risk taking satisfies the fault, so should lead to liability towards victims of NCII whose images appear there. And then I have a chapter that deals with the argument that liability should be strict because the relevant intention is intention to act, not to harm, which is the classic position of trespass torts. And it was also, recently confirmed in the Supreme Court Lloyd and the Google case. That dealt with the differences between awarding damages under data protection and under misuse of private information. So the relevant distinction in terms of viewing is whether the viewer is passive recipient or not. And in this sense, the criminal law defenses to offenses of possession of child sexual abuse and exploitation is a good starting point. As I mentioned earlier, due to the overdetermined causation, liability should be part of the overall damage, so neither full nor proportionate. And here I mainly piggyback on previous work that I've done in the second monograph, that I made a special case for liability for creation of exploitative demand. If you buy sexual services in a market in which there are victims of sex trafficking, so I argue that this should lead to liability under negligence, but to a sui generis level of compensation, which is not full nor purely proportionate. So I think that the same solution should be here in the case of viewing. And as I mentioned earlier, I deal with issues, some of hot debates, at least in England, about the development of misuse of private information and the overlap with defamation. So I say again, as an intentional tort, the remoteness test should be directness, and not foreseeability. The tort should compensate for reputational loss, and damages in principle should be given both for loss of control, but also for any consequential losses. Again, this is not really a problem in a case of NCII in which there will be no significant consequential damages from the breach of duty. Okay, so sorry. So now I would like to turn to the first point, the defending the relevance of a property approach to private information in terms of the remedy that I'm looking for. So in terms of conflict over titles, so it has many instances, but the most classic one is the competition between the title of the original owner and one who bought it, so even bought it in a regulated market. So here there are two solutions, the American solution, and currently it's also the English one, the theft rule, the nemo dat rule. So the original owner always wins. And then the other one, which is more in a civilian system, although there was a common law approach till relatively recently, of a market overt, that if you buy in a regulated market in good faith for value and get title, so then you win. But what is important is that the seller, the merchant, will be liable in conversion, which is the main point that I was making. So I would like first to get your attention to the similarities, the significant similarities between the stolen property uh, chattels scenario and hosting and viewing NCII. So first of all, in both cases, there are four actors. There's the original owner, which in the NCII context is the subject of the intimate image. There's the thief. The equivalent of the thief is the person that initially had a take, but definitely disseminates without authorization the intimate image. There is the host, which is the functional equivalent of the merchant who sells. And there is the viewer, who's the functional equivalent of the buyer. Second point of similarity is that in both cases, the intermediaries are repeat players. And this is important because, again, first they do it for profit. So it's relevant, what I captured in the bullet point, the third bullet point, for the policy considerations to have them strictly liable. Because, they have control over the situation. They have the possibility to try and inquire whether what they sell is authorized or not. And they are good law spreaders, since they're repeat players. So if they do happen to sell stolen goods or unauthorized images, so they could pay for the losing part in the competition. And this is an observation of Hanoch Dagan, who wrote about conflict over titles, that the merchant actually serves as an insurer of the defect of the title. So, the loser, whether it's the original owner or the buyer, could sue, one of them in conversion, the other one in contract. Perhaps most importantly, the fourth similarity is that conceptually and normatively, it's very similar because in both cases, we complain about defect in title. So both if someone still sells my stolen car or my stolen intimate images, the problem is that they don't have right, they don't have title, to either to sell the car or to give access to my images. And then the last point is a bit less intuitive, but I think that private information is more similar to chattels than to copyright when we think of it in terms of public good, in terms of rivalry and excludability. Because, Anthony's right to see my intimate images is rival to my right to exclude him. We can't have it both. It's either or. So in this sense, there is a similarity which wouldn't necessarily work at the same extent when we think about the IP rights, like copyright. Obviously, there are also differences between selling stolen chattels and hosting images. So I will discuss them, but to my mind, they don't change the conclusion. If at all, they just make clearer that in the competition between the original owner, the subject of the image, and the viewer, so the rights of the NCII victim should prevail. So first of all, there is the challenge, which it's a big controversy in privacy law, whether it's useful to think of it as a property right or rather just as a personal right, or in other words, whether the right to privacy should be considered as inalienable. So I'm not convinced by this for two reasons. First, when we look both at the law and the practice, we see that private information is alienable in the sense that I can sell it if I want. So, both like phenomena like OnlyFans, and also it came in the in the case of Douglas and Hello, so Katrina Zeta-Jones said it's important for actors, especially for women, to have control over their image, for commercial purposes. So we know that I can sell my private information. So in this sense, it is a property right because it gives you the right to exclude you unless you pay for it, yeah, and for an amount that I agree. But even if we were to accept that the right is or should be inalienable, then it takes me to what I call the inalienability paradox, that it doesn't make sense that the legal system would protect an inalienable right to a lesser degree than an alienable right, because a right could be either alienable or not. If it's not, if it's inalienable, it's because we want to have it less circulating, less sellable. So then how come we give the original owner weaker protections against third parties than we would to someone that has a property right in which we accept that we could, in principle, alienate the right. A second objection, which I address in the book, but I won't talk a lot about it here, is that obviously conversion and conflicts over titles. It's about personal property chattels. Should it apply to intangibles? So I'm not making a general claim about intangible. I'm just saying that here, for the reasons that I explained, including the difference, in terms of rivalry and excludability, so the principles governing conflicts over title should be applicable here as well. The third observation is that in resolving conflict over titles, and again, especially for solutions which are market overt, which are exception to the original owner wins, the nemo that rule, which is perhaps the starting point. So in cases when the original owner loses, part of the justification is that the loss for the person that doesn't have title is roughly the same. Roughly the market value of the chattel. And again, some of you might be familiar with the work of Manny Mautner about that, the eternal triangles of the law from 1991. But so this and some other considerations could justify sometimes the solution that the viewer would win. But when we look at NCII, we see that the damage, the harm to the victim of NCII is much more significant than the damage to the viewer if they are not allowed access to the intimate image. So this in itself strengthens the hand or the right or the claim of the viewer, and should be translated to how we regulate the sellers, the platforms. We could also observe that technically, the viewer, could not be considered as a buyer. It's not a buyer because it doesn't get titled, to the copy or to the image. Also, typically, they would not provide value because even if it's behind a paying wall, you don't pay per image. So, you can't say that, that you bought the right to the specific image. More generally, and this relates to the symmetrical and asymmetrical harm, we can't really identify a legitimate interest for the viewer to win in this competition against the subject of the image. So whether we think of it in terms of security of receipts or in terms of freedom of expression, there isn't really a legitimate interest of the viewer that could, tilt the balance towards them. So both the viewers, but even more so the seller, should be liable towards the original owner. And then the last point I mentioned earlier, the understanding of the merchant intermediary as some kind of insurer. And here we should see that damages from the merchant are adequate or more or less adequate in the case of stolen property, but are much less adequate in with the dignitary and reputational harm in cases of NCII. So again, this also suggests that the NCII victims should have stronger rights against the intermediary and the viewer than in cases of stolen chattels. So in terms of concluding this point, another observation which is important is that in conversion, each of the persons that undermine your rights could be sued. So, if it passed from 3-4 people, you could sue each of them. So the fact that the poster, the uploader, the equivalent of the thief is available, even if I know who they are, doesn't prevent me from suing the merchant, which obviously it's important because the platform is likely to be able to pay, unlike many cases the individual poster. In the absence of legitimate interest of the end user, of the viewer, so we can't justify immunity to the intermediary. This also implies, strict liability, as is the case in cases of interference with property right. And then I also make the point that unlike the entrustment exception in conflict over titles, that if I departed from the chattel voluntarily, as part of a contract or a bail or whatever. So then the third party could get a good title under certain circumstances. This should not be applied. For example, in cases that I sent to my girlfriend my image and then she distributed it without my consent. And this goes back to the issue of absence of legitimate interest. So security of receipts, security of transactions is much more important in the context of chattels than in the context of intimate images. So we shouldn't accept an entrustment exception. And in this sense, we should also recall that, first of all, market overt is not the accepted rule in Anglo-American systems. And also that we have good reasons to doubt whether it should be considered as, as a regulated market, especially, for example, in the case of a porn platform. So we could also doubt sometimes, the good faith element of the viewer. And then I think that this analysis also, supports strict liability of viewers, not only of platforms. And the last point is that we don't need to channel the claims of NCII victims to the tort of conversion. It's sufficient to consider the tort of breach of privacy as strict, since the intention should be to act, not to harm. And as I mentioned, after I started the project and after that I wrote a chapter, there was this case of Lloyd and Google, which actually said that the misuse of private information is an intentional tort, which is actionable per se, for intentional act. And it's also compatible with the approach of Justice Sotomayor in Powerline. She was in dissent, but not about this point, the observation that, viewing child pornography is a serious breach of privacy. Okay. So moving to the second point, about the policy and what I call NCII exceptionalism and the critique of the inverted hierarchy. So in the regulatory space, my suggestion is exceptional, for an exceptional treatment, in the sense that the starting point is that there shouldn't be general monitoring duty on platforms, which generally understood to forbid filtering, or it is no obligation of legal obligation of filtering. So I suggest that with respect to intimate images, there would be a filtering obligation. So you need to filter out intimate image unless you have a verification that there is consent by all those depicted in the image. However, this general monitoring or filtering duty should be extended to defamation, copyright, and other rights violations. And the reason is that on both parts, for the balancing, both in terms of the harms and in terms of how easy it or how burdensome it is for the platform to monitor. So we see that NCII is very different from a potential or a text which is potentially defamatory or in breach of copyright. So in terms of the harm from NCII, it's severe, multifaceted, irreparable, gendered, systemic, and a form of sexual abuse. So I would like to say a few words about that. It's severe in the sense that, again, since it's also a form of sexual abuse, so it causes, really serious harm. And, we do know that some victims of NCII committed suicide or attempted to commit suicide. I don't know of many copyright holders that, try to commit suicide, due to the breach of their right. It's multifaceted in the sense that it affects many aspects of the victims, both online and offline. So it affects romantic relationship, social relationship, employability, relationship with the family. Sometimes it causes follow-up abuse. Sometimes to move out. It undermines your digital citizenship. So it really affects you in numerous, almost all aspects of life. It's irreparable in the sense that award of damages is not good enough an option. So it's also lasting. Both the infringement, sometimes it lasts, and the effects. And I would like to say a few more words about the gendered and the systemic aspects. I think that, again, as Anthony mentioned at the beginning, I think it is especially, hopefully, good fit with this particular network. So based on previous work, which started with the first monograph that we did before, so I argue that egalitarian considerations are a separate, independent reasons for or against the rule. So if the result of the rule is regressive, this is an independent reason against adopting it. It wouldn't necessarily be the trump card, but it's something that needs to be taken into account, regardless of other considerations. And I argue that the phenomena is gendered, for 5 main reasons. First, women are more likely to be victims than men. Second, women will typically suffer greater harm from being NCII victim than men due to the double standard about sexuality. Third, men are more likely to be women. NCII arguably affects all women, so it's a group harm by reinforcing patriarchal order and entrenching a norm of shaming sexually liberated women. And fifth, arguably, it is often motivated by misogyny, or at the very least, the choice to disseminate intimate images is not unrelated to the victims and perpetrators' gender. Now, against that, someone could argue that I'm talking about claims against platforms, and platforms, if you like, are corporations. They are not that gender neutral. But I think I have 5 answers here why this is not a good answer against understanding the phenomena as gendered, and relatedly is the further justification to remedy and to regulate. So first, even if the typical defendant is gender neutral, so is random or heterogeneous, as long as the typical claimant is a woman, liability should be supported as a matter of egalitarianism or progressive distribution of entitlements, which again, it's also a claim that I made in other contexts previously, including buying sexual services. Second, the group harm nature of NCII makes the harm gendered regardless of the identity of the defendant. Third, when relevant defendants are assessed as a group, uploaders, intermediaries, and viewers, defendants are typically men. This holds true even if intermediary liability is sort of as primary and independent, but even more so if we think of it as accessory or secondary. Fourth, intermediaries are a major societal force in maintaining, reproducing, and profiting from gender and patriarchal norms. So this makes it fair to expect them to pay for the gendered harm they facilitate. So here I'm saying that both an egalitarian commitment and what I would call, Echitian notions of fairness, linking harms and benefits, go together to explain why platforms which benefit from it should be liable for the damage. Um, and, and then I say that this renders unnecessarily examining a fifth claim whether it's correct, which I think it is, but it's less crucial, that lifting of the veil would reveal that those who profit from and control the relevant intermediaries are mostly or disproportionately men. And just a couple of points about the systemic. I think that the harm is systemic or systemically gendered, and that this also serves as the reason why the harm is exceptional, or the violation of the right is exceptional, and justifies this exceptional monitoring duty. So one aspect, I think that there are three. It's both entrenches and a manifestation of patriarchy in the form of sex-based discrimination. Second, it created by many individuals, but also by social structures and socialization. So in terms of individuals, we can enumerate the uploader, the intermediary, secondary distributors, viewers, and those who act on the information, either for further abuse, harassment, or discrimination, based on the intimate images. And third is the group aspect that I mentioned earlier. It harms women as a group. It regulates their sexuality, and so to speak, the point is to keep them in their place, and to undermine their equal citizenship, including digital citizenship. So, and then what I do in the relevant chapter is to try and show how private law, doctrine, and theory could justify this regulatory response. So a first point is the distinction between primary and secondary duties, and the understanding that it's better to prevent a wrong than to correct it. So here I rely a lot on the work by Gregory Keating, both in terms of theory of rights and also in terms of just regulation. Then the distinction that I mentioned about interim injunctions. So tracking the difference between the availability in privacy and inavailability in defamation could justify monitoring duty for sexual privacy, but not for defamation. And then I also look into anticipatory injunctions, quiet timid, in which the irreversibility of the harm is important in deciding whether to give it, but also the chances that it will occur. And again, if we think of it from an aggregate perspective, as a mass tort, so it's certain that without filtering, some, and not very few, but some victims, many women would suffer a serious harm from it. So, since it's sure to happen and would cause very serious damage, so it justifies the monitoring duty. So in this sense, the monitoring or filtering duty could be the functional equivalent of an amalgamated or aggregated quiet-timid injunctions. Okay, how much time should I stop here or go on for a few more minutes? What?
Yeah, I think you can continue. Just keeping in mind we're going to record and put this online, so
Sure. Yeah. Okay.
people would love to hear you speak beyond that.
Thank you. So the other side of this NCI in exceptionalism is just the observation of what I call the inverted hierarchy. So while, according to my analysis, the order in terms of how precious the right is should be, sexual privacy, perhaps other aspects of privacy, then reputation, and then copyright. What we see on the ground is what I call the inverted hierarchy, in which copyright holders have stronger rights against intermediaries uh, than um, uh, privacy right holders. So we see it in the US, the Section 512 of the Digital Millennia Communication Act creates safe harbor, roughly notice and takedown, for copyright in terms of copyright. But Section 230 of the Communication Decency Act gives complete immunity. And in the EU, and the analysis in the book, preceded the Digital Services Act. But the starting point is a horizontal approach. But the CDSM, the Copyright Digital Single Market, created de facto something which is or very close to general monitoring duty. So again, that we see that in both jurisdictions, there is priority to copyright over privacy. And I think that there are other policy implications of NCII exceptionalism, which I mentioned in the book. So one is a critique of the horizontal model. And in this sense, the approach in the Online Safety Act 2023 in the UK is in the right direction because it creates different regulatory duties based on the harm. But my critique would be that they should have bumped up the protection given to image-based abuse. Second, my approach could support and does call to treat image-based abuse as a form of hate crime. So this is a problem which is not limited just to NCII. It's a general problem that we see in criminal law in the regulatory space. We don't see gender-based harm and motivation as a ground to see the crime as aggravated as a hate crime. So I criticize that in the book. The third point is vindication of the European Court of Human Rights decision in Delphi, which is quite unpopular for media lawyers and human rights lawyers, and particularly the regulation of platform lawyers. But I think that the approach there makes sense. To me, it's a manifestation of vertical approach. So the duty to actively monitor is a function of the fact that the harm or the undermining of the right is more serious, in that case, hate crime. And lastly, which I will talk about it a bit more in the next time, which is my last, is reducing the regulatory gap between image-based abuse in general and child pornography. So I think it's important to understand that both phenomena are on the spectrum of sexual abuse, and actually, child pornography is just a subcategory of the general problem of NCII. Now, it's true that if the child is depicted as having some kind of sexual activity, so this would necessarily be, a criminal offense against them and cannot be consensual. And it's also true that, adults obviously could agree both to have sex and to have their intimate images circulated, which children could not. But for those who did not consent, to either the underlying sexual act or to the disseminate, or or, to a photo of them being taken intimately, or that this was consensual but not dissemination, so the harm is very similar. And yet we see a huge difference, a huge gulf between how child pornography is being regulated also in terms of criminal responsibility of viewers and what is expected of platforms to do, and the lack of such expectation, the relative lack in terms of platforms. Um, I will skip the McKinnon quote. It's something that I also used in my second book about sex trafficking, but I think it's an interesting point that shows that we can't really think of these two things as unrelated. Um, but what is interesting is that even those who are truly committed, either academically or in terms of activism to fight NCII, so they stop short of suggesting to criminalize viewing. And so people like Daniel Citron and Mary Franks, and I also mentioned in the slide some kind of organization. So they don't think, for example, that viewers should be criminalized for possession. And in the regulatory space as well, we see that there's a big difference in terms of the duty of care and code of practice, and the things that the platforms need to do with respect to CSAE, and in what they are supposed to do in cases of NCII. This was reduced a bit, and I did respond in the relevant consultations for the Online Safety Act. Because at the beginning, when the white paper of Online House was published, they didn't even refer to NCII as a priority offense. And I and others, responded to that, and now it does appear, but still it's not treated, or not treated the same for sure. But there's still quite a big gap between how platforms should deal with NCII and how they should deal with child pornography. I'm not sure that that big gap is justified. So I will stop here. Thank you very much.
Thank you so much, Sashi. I think as an area of law that I'm not quite as familiar with, and so really benefited from the opportunity to learn a lot from it. So we'll open it up for Q&A. I noted that Zoe left a question for me to convey, and I also had a question that was kind of similar to hers. So, but before doing that, I'll invite others to raise their hand using the hand raise function. Zara, to begin, if I'm pronouncing your name right, please feel free to ask your question, and then I'll jump in with others.
Yes, hi. Thank you so much. So my name is Zahra Takshid, and I'm an assistant professor at University of Denver. So I joined a little bit late, so I apologize if you already covered this, but I'm going to ask it anyway. How do you view accidental viewers, and whether someone could actually, or not whether, how someone could actually prove that I did not meant to watch this and it came up on my feed? Because I think like maybe some of the reasons that you mentioned, maybe Professor Citron thinks that it doesn't make sense to punish a viewer, which I actually disagree, and I think like there should be ways to think about how the viewer should also bear the liability. So I'm in that camp. But as a practical matter, I'm thinking, how can we prove the intention to watch? I mean, sorry, I know it's a strict liability, but how can someone actually say it? Okay, so did I actually answer my own question that because it's strict liability, you can't prove otherwise?
Yes and no. So I say liability should be strict, but I think we could learn lessons from defenses to child pornography possession offenses. That again, if you are passive, if you were sent and didn't know, or sent and you didn't open it and didn't know that it is, or you open it and immediately deleted that. So then there wouldn't be criminal responsibility. And under my suggestion, so again, if we adopt that, so you wouldn't be liable. So the difference is whether you are active or passive. Now, if you're active, so again, you take the risk that the intimate images that you looked for are non-consensual to the same extent that I take the risk that if I buy from you a car and it's stolen, so I lose the title and I'm liable for for in the tort of conversion. Yeah. So this would be my suggested distinction, not whether there was an intent to harm, because the relevant intent is a strict liability tort should be intent to act, not intent to harm, but rather whether you were active or passive.
Yeah, thank you so much.
Thank you.
I think, Tsachi, I had a similar question as that, or maybe that touches on before going to Zoe's, I guess, which I also had a similar question. But on this point, I was reading recently the Supreme Court of Canada's decision in a case called Sharp, which dealt with the criminalization of child pornography, and like you're in line with what you're saying. A lot of the sort of discussion there, like it was a sort of concession by the Crown that the offense limited freedom of expression, right? And so the question was, is the limit justified? And a lot of that turned on what available defenses there were to it. And the Supreme Court ended up saying, yeah, some of these defenses are important. Like there's like protections for artistic expression and other forms of expression. And it ended up having to read in things like defenses for simple possession and not viewing, that sort of thing. But a lot of that debate is animated by the sort of assumption that there's some value of freedom of expression going on here, right? And that we need to be able to shape the defenses to protect that to a legitimate degree. And I was just wondering, like, how strongly, if at all, you think the value of freedom of expression plays out in the private law context? Because I think what you ended up sort of saying in the talk, at least, was that when we're doing the relevant balancing, there's just not a significant freedom of expression interest here. But it just it seems like, why have the defenses? And also it might affect the level of fault, right? So if we think that freedom of expression has some value here, we may be more interested in some fault standard rather than strict liability. And just keeping in mind for me that, like, at least when developing a law of defamation, the Supreme Court has been willing to entertain the idea that freedom of expression does matter even for the expression of defamatory statements. So like there is a relevant balance going on. So I was hoping you could expand a bit on that.
Sure. Yeah. So again, very good question. And I have, few thoughts about that. Again, that most of them I think were in the book. So one thing is that freedom of expression is a double-edged sword here, because we should think not only of the expression of of viewers or platforms, but also of sexual oppression, of sexual expression of people that are at risk to be victims. And again, practically it's mainly women. Now, unless you know that there is a robust protection for violation of sexual privacy, it might limit your sexual expression, because you wouldn't take intimate selfies, you wouldn't share them, because again you would be afraid that you would be without a remedy. So even if you think that sexual expression is important here, it doesn't necessarily say that it should limit the remedy. Remember that I did respond to consultation, which dealt mainly with the criminal aspects, but the book is about civil civil liability. Now, obviously, freedom of expression is relevant to civil liability, like also in the defamation and Article 8. So my point is not that it has no place at all. But actually, when you look about this particular expression, uh, it's not a high value one in the sense that, first of all, as I said, those who would like to, disseminate their intimate images would be able quite easily to do so. So it would cause mainly a delay. Yeah. Because again, I put it, the AI didn't know that I consented, so they took it down. I find it out, I signed the form, whatever, and then it goes back. So I lost 2 weeks that my nude image wasn't there. It's not really a big loss in terms of, autonomy and in terms of sexual expression. Yeah. Uh, the reverse is not true. If my intimate image is put there without my consent and you didn't filter it out, now the horses are out of the stable, yeah? And the harm for me is very, very serious, including for my sexual expression, because again, of a chilling effect, but also, much broader than just sexual expression. So the balancing doesn't even start to be a close call here. Yeah. Um, so again, now we talk about intimate images. The internet is full with them. You can't really say that viewers have a legitimate interest in seeing a non-consensual intimate images. So, but there's no the real argument is chilling effect. Platforms with but this I already answered. I don't think that it's a convincing one because those who would like to have their images would be able to have it, by authenticating then consent, and then we don't have any significant loss of expression due to my suggestion.
Yeah, I think I sort of I'm on board with you when it comes to the sort of the ultimate balancing act, right? It seems kind of almost like just really difficult to see how the balance could come out in any different way, or else we wouldn't be having a regulatory conversations. Having said that, it seems to me that from what you're saying, that it's not that there's nothing to justify, right? It's not that these harms to autonomy and privacy, and also the gender-based harms. It's not that they are kind of competing against nothing, but there is some cost, although albeit a very small one, to freedom of expression. So it's not that there's no wrong is just a justified wrong, easily justified wrong. I think my point is that even in some circumstances, the cost to freedom of expression may exert some influence in the same way that
Yeah,
any moral remainder has kind of an influence.
yeah, I don't have a problem with that.
Yeah.
Yeah.
No, that sounds right. I'll get to Zoe's question as well because I may end up. And I think. Okay, so Isabel has a question too. So I'm just gonna go with Zoe first, and because she put it in first before she went. But Isabel, you'll go next. Okay, thanks. So let's see. So Zoe says she's asking about the expressive value of tort law, which is interesting. That's what we were talking about right before the talk. Whether she says whether it has a role to play in the treatment of NCIIs and the liability of platforms and viewers. So I think so she says the core of the wrong is a wrong against a person. It's more akin to defamation than conversion. And so she's worried about whether looking at it from the perspective of property kind of undersells what's going on with this wrong. So maybe to put like my own spin on that same question. So I was wondering too about the property analogy. So when actually it seemed like you were viewing it as a kind of hybrid wrong, right? Because you don't want to completely transport rules of conversion into this context because you want to sort of base it on intrusion upon seclusion and the dignitary harm and not necessarily the sort of loss to property, whatever, disgorgement of profit, like all of the kind of property-based remedies. But I wondered though that in line with what Zoe was saying, this is not just any kind of property wrong, even if we accept the the property-based analogy, which you seem to accept by looking to intrusion upon seclusion and dignitary harm too. So think about this. We could also run an analogy with property by saying you took my information, but not my intimate information, like my images. You sold my email to some listserv, or I'm totally happy to disseminate information about my education and publications online. There's no problem with that when somebody takes it. But we're dealing with something special here. We're dealing with incredibly intimate images, which makes it a sort of a special case of a property wrong, even if we understand this as property. And we may, the expressive point is we may want to mark that out in a special way, not by assimilating this to things like conversion or even intrusion upon seclusion, but dealing with it on its own terms as a serious invasion of a certain kind of of privacy. I guess that was my spin on Zoe's question, but there's a lot of stuff there to speak to.
Okay. So let me try and answer, both Zoe and the spin. First of all, you wouldn't be surprised to know that I heard this question a lot, yeah?
Yeah.
Now, for those who might or might not be, familiar with my previous work, so I have a history of trying to use property right in a progressive way. I could say that probably the most controversial paper that I ever presented, which was eventually published in Law and Philosophy, was the argument that since victims of sex trafficking were treated like chattels, so they should be able to sue viewers in Jones, clients in conversion, which is strict liability. So again, so it gets lots of similar concerns about expressive and about commodification. Yeah, I really don't. I'm not convinced by this critique, for two reasons. First of all, I think that the situation is commodifying, not the legal response. Yeah. I also, in that context, sex trafficking suggested the distinction between ex ante and ex post. So again, obviously, we don't want humans to be treated as chattels, but this happened, and there's already economic benefits of it. Now the question is distributive. Who should have the gain from it? Is the trafficker, or the victim? Because there are two different issues here. Whether you could sue in, like, for example, restitution, the traffickers for the gain. So again, there's some reluctant to do it, based on expressive, and whether you should be able to to claim that you were treated as chattel. By the way, interestingly, the international criminal law definition of the trafficking is being treated as property. So how come for criminal law it's okay, but for tort law it's not? So yeah, but I have another answer which I think is relevant for both contexts, and that the expressive problem, it depends on how you conceive of it. And if you understand that this is a move, by the victim in order to afford them better, rights or remedies. So again, who are we to tell them, no, it's offensive to you, it's offensive to, to other women, or whatever. So I think that especially in private law, it has empowering potential, in the sense that the victim controls, or the claimant controls, the process, and they could decide, whether they see themselves as victims, who they want to sue. Do they want to sue the platform? Do they want to sue the viewer? Some would, some wouldn't. Yeah, and if so, how do you conceive of that? Is it a property aspect? Is it the gain that is based on your expense that offends you? Both. So I say, we can't hang into expressive arguments which on the merits could be more or less convincing, in order to override how the victim themselves sees themselves and conceives themselves. So again, perhaps there would be victims that would find offensive the idea of conversion. Okay, don't go for it. So again, in terms of sex trafficking, you don't think that the viewer is that the client is responsible, don't sue them. You think that it's only a matter, of the battery, but then not a conversion, sue in battery. But for those who think that they want to sue whether because they think that it fits their experience or that they could get something material out of it. Who am I and who are we as a legal system to tell them that we overwrite you when conceptually this is the case, and it also fits with how you conceive of your experience. So this is the general answer. Specifically in this context of NCII, I would say that this is something that again I developed in this book, is that I'm not committing myself to say that private information or sexual private information is property, despite the fact, in brackets, and I mentioned it in the talk. In fact, it is. I can go tomorrow to OnlyFans and get money for sharing my nude images. But if you, Anthony, would do it without my consent, I should and would be able to sue you. So this is a property right. But regardless, I don't need to commit myself to the view that sexual private information is or should be property. All what I should argue, and I hope that people would accept, is the idea of the paradox. It doesn't make sense that if I say that it shouldn't be property, because it should be inalienable, so then you will be able to get out of the hook more easily if you're a third party that undermined it. Then, if we say that I have property right and I could, if I wanted, to alienate it. That's my point.
Thanks. That raises a lot of interesting questions, and maybe we could talk a bit more offline about them too, because I think we could. But I want to make sure I get Isabel's question in, which is an interesting one. And I was wondering to what extent your framework applies equally to both real NCII and to deepfakes as well that are NCII.
Yeah, sure. Again, another great question, like all of them. So initially, when I put the book proposal, I had a chapter about, or planned chapter rather, about deepfakes, and then I ran out of space and time, so I took it out. And then last year in May, or this year in May, say half a year ago, I was invited to a conference in London about the deepfakes and the law. So I talked about the deepfakes in this context. So my position is that it should apply. It should apply to deepfakes, at least, for the dissemination of them. I'm less clear that creation for self-use of deepfakes should be either criminalized or as I focus would give rise to civil liability. In the UK, they are now in the process of amending the OSA, the Online Safety Act, in order to create the making of a pornographic deepfake also a sexual offense. But in terms of civil liability, I think that the dissemination and the hosting, and again, I would say also viewing of pornographic deepfake should lead to liability. I think that the most interesting question there is, what make it private? Yeah. But I think that yeah, so I think that the idea of privacy is again some kind of no zone, for others, including about the visually depicting how we look. So it's not whether it's true or not. Yeah, it's not defamation. So how I look beneath my clothing is a private matter. So if you depict something which is not, again, especially if it comes across as true, so it would be breach of privacy. I think if it doesn't come across as true, it makes it more problematic. Then we also go back to issues of freedom of expression in terms of parody, perhaps. But I think that possibly, perhaps, I don't have strong views about it, or I need to think about it more, but possibly it could be justified. I'm not necessarily sure that on ground of breach of privacy, but again, perhaps it's some kind of, excluding. We know that, deep fakes are being used against, female celebrities, politicians, so it's a form of, again, denying equal citizenship. So again, perhaps some kind of, harassment or something like that. Conceptually, I'm not 100% sure if it's a privacy or not, if we know that it's a fake. But definitely, if we can't tell whether it's fake or not, so then it's a breach of privacy.
Okay, thanks. And maybe it makes sense to wrap it up there, Tsachi. I'll stick around for a bit too, and I'll invite anybody to do it, but I'll stop the recording now. And that'll mark the end. So thanks everybody for, and I think I should also mention Zaha posted a link to a paper that's on point and that may be of interest to the participants here.
Great, thank you. I'll copy this.
Yeah.
Thank you very much, all of you, for joining. I really enjoyed your questions, and thank you for listening.